Decades after jazz musician and composer Duke Ellington died, Duke's grandson Paul sued publisher EMI Music over royalties from Duke's music. Would the court's decision in Ellington versus EMI Music leave Paul in an indigo mood, or would he take the A train to victory? In 1961, Duke executed a copyright renewal agreement with several music publishers, including Mills Music. The agreement identified Duke and several named family members as the first parties and was explicitly binding on Duke's heirs. The agreement designated Mills, the other publishers, and any other affiliate of Mills as the second party. Under the agreement, Duke assigned the right to renew the copyright for certain specified compositions to the second party. In return, the second party agreed to pay the first parties 50% of the net revenue the second party actually received from foreign publication of the compositions, after paying the foreign sub-publishers' fees. When the parties signed the agreement, domestic publishers like Mills generally weren't affiliated with foreign sub-publishers. However, this circumstance changed over the ensuing decades. Paul Ellington, Duke's grandson and heir, learned that EMI was using affiliated foreign sub-publishers to publish Duke's music abroad. These affiliated sub-publishers retained 50% of the royalties generated by foreign sales. EMI and the first parties split the remaining 50%, pursuant to the royalty provision. Paul sued EMI for breach of contract. He alleged that the money retained by EMI's affiliated sub-publishers constituted income received by EMI from foreign publication of Duke's music. Therefore, Paul asserted, EMI owed the first parties half of the entire amount generated by foreign sales, not half of what was left after the sub-publishers took their fees. The trial court granted EMI's motion to dismiss the complaint. The New York Appellate Division affirmed. The New York Court of Appeals granted review.